In the last few videos, we have talked about cross-border data transfer and the requirements of conducting DTIA, that is Data Transfer Impact Assessment, when moving data out of a European Union country to a non-adequate country. In this video, we are going to discuss some of the common challenges that organizations face when they are conducting a data transfer impact assessment. Welcome to my YouTube channel, where you daily find new content on data privacy, and as I mentioned, we are going to talk about the challenges that organizations face when performing cross-border data transfer. So what are those common challenges? Prior to getting into the real challenges, let's relook at the definition of cross-border data transfer and the data transfer impact assessment. There are a lot of countries who still do not have a proper structured approach towards how they handle the privacy of their citizens. CBDT, cross-border data transfer, implies that you need to conduct a data transfer impact assessment and maybe impose the standard contractual clauses and binding corporate rules if in case you feel that the destination country is non-adequate, and non-adequate country is the country where they don't follow any very strict laws to handle the data privacy of their citizens. So would they be capable of, or would they even like to handle the privacy of your citizens when your citizens' data go there? That's what you have to find out conducting a data transfer impact assessment. The common challenges that you face doing a DTIA or data transfer impact assessment start up with the third country laws. You need to be very clear on what kind of law is there in the country where you are transferring data. And there are many instances where there is a lack of clarity. It's a difficult process to understand the legal framework adopted in the remote country. There is an ambiguity about their models of governance towards their data handling practices, and an ambiguity over the enforcement of data protection laws and data subject rights in the third party countries or a remote country where you are not yourself present. The process of moving that data could also be because of low cost processing or a disaster recovery site for storing the information, but then you have to be very careful about that the data should not get breached from there. Other challenges include an uncertainty around adequacy of safeguards. They say, but do they really apply the standard contractual clause or the bonding corporate rules that you impose on them? Are there risks because there are poor access management there? There is very poor security in terms of encryption and anonymization there. If encryption is applied there, is it really effective? Is there any effectiveness to it? What about the complexity of cross-border data transfer? It's difficult to monitor multiple countries, right? If you are outsourcing your activities, or if you are moving your country's personal information to many countries, it is not very easy for you to monitor multiple countries and laws in multiple countries. There are different regulations in each country, and they do adhere to safeguards, and it becomes difficult that to monitor whether they are adhering to the safeguards that they have promised to you. And then we move on to the lack of resources. They have very limited legal or privacy teams. You also may not have very large privacy teams, especially when you want to dedicate those privacy teams to cross-border data transfer only. They have a lot of things to do in privacy in local as well. The data transfer impact assessment needs extensive research and documentations, and there is a shortage of official tools and techniques available to conduct a data transfer impact assessment. So another challenge is evolving regulations. Are you updated? It's difficult sometimes to take care of your own updating regulations, then taking care of the updated regulations of remote countries, maybe many remote countries. So there is a difficulty around there. So what kind of updates you can apply in your system in your country, that you are always updated on the changes happening in other countries, and you always stay updated with the legal precedents that are set in the remote country. So these are the few common challenges that you face when you conduct DTIA for moving data out of a European country to a non-adequate country. I hope you like the content, so please press the bell and the like icon, subscribe to my YouTube channel if you have not already done that, and share your feedback in the comment section. Thank you.